Hello and welcome. This webinar is part of the Legal Awareness Initiative taken by the Law Gurukul. In today's webinar, we'll be talking about the various sections of the Information Technology Act that everyone in this day and age should be aware of. I am Anoushka and I will be one of your presenters along with Ms. Shabnam. In our previous webinar, we spoke about what cyber law is, about its essentials. Today, furthering that cause, we will dwell upon more relevant sections of the IT Act. Ms. Shabnam, over to you.
Thank you, Anoushka. So, good evening to all. Today, I'll be explaining to you Section 43, 66, and 67 of the IT Act 2008. We have handpicked few relevant sections that will be helpful to all common people watching this. All right, now moving into Section 43. Basically, it is penalty and compensation for damage to computer system. That is, whoever without the permission of the owner of the computer or computer system or any other person who's in charge of it will, and if he commits any of the following data breaches, which is either accessing without the permission or downloading or copying any information in the database, or downloads it or inserts virus into the system, and in any manner causes disruption to the normal functioning of that computer, will be held liable, and they will face a punishment of up to 2 to 3 years along with a fine of 5 lakh rupees or with both. This basically includes all sorts of offenses in which a third party will access your computer or computer system and causes a form of nuisance to you all. And under this Section 66, we'll also look at the aspect of basic identity theft. Now, identity theft isn't something that's alien or which is not known to us. We've seen it in different forms as people impersonating somebody else on social media, or basically stealing any sensitive information or personal identification marks and using it for other miscreants. So basically, Section 66C is regarding punishment for identity theft. Whoever fraudulently or dishonestly uses the electronic signature, password, or any other unique identification feature, they shall be punishable up to 3 years and a fine of rupees 1 lakh. And if this identity theft goes to an extent of cheating by personation, then it will be a violation of Section 66D, which is basically brings a punishment of 3 years and 1 lakh rupees as a fine. Now, besides identity theft, this can go to a more extreme limit where they'll breach your privacy. And this is covered under 66E, in which basically if anybody intentionally or knowingly captures, publishes, or transmits any image or content of any private area of your life without that person's consent, of course, it is considered to be a violation of that individual's privacy. And this offense is punishable by 3 years or a fine of 2 lakh rupees or maybe even both. Now moving on to Section 66 of the IT Act 2008. Basically, this section covers all form of transmission of obscene content and sexually explicit content. Now, first, in general, Section 67 is regarding publishing or transmitting any lascivious or that content should appeal to a prurient interest. Now, it is to be noted that the word obscene isn't necessarily defined, but however, there are certain tests which will be discussed next. Anyways, this is punishable, but the first offense will be punishable by 2 to 3 years and a fine of 5 lakh rupees. And any more subsequent, breaches would be punishable by 5 years of imprisonment and a fine of 10 lakh rupees. Now, moving on to Section 67A, it is basically not different. It is regarding obscene content, but specifically for sexually explicit content, which is also punishable under this. And for the first offense, the punishment is for 5 years of imprisonment and 10 lakh rupees is fine. And for any more subsequent, repetitions, the punishment will be for 7 years and up to 10 lakh rupees is fine. Now moving on to what is the concept of obscenity in terms of our judiciary. Now, the first test that used to be done regarding obscenity was the Victorian era Hickling test. In 1965, it was first used in Ranjit Udeshi case. Basically, the facts of the case was the defendants were book stall owners, and they sold a book called Lady Chatterley's Lover, which was by then standard considered to be an obscene content. Of course, this doesn't come under IT Act. It will be more of a violation of Article 292. But however, we are discussing the concept of obscenity here, which will be the same in the IT Act. The test assessed obscenity by a standard of someone who was open to immoral influence and was likely to be corrupted or depraved by the material in question. In simpler words, the test of obscenity then, that was the Hickling test, was on the standard of somebody who was open to be influenced or who was vulnerable to such content, and not by a conventional system or a conventional citizen of the country. However, in 2014, Avik Sarkar's case, things changed. The facts of the case was, so there was a tennis player named Boris Becker who had a nude photo shoot with his wife, and they were an interracial couple. So it was more of a statement against the apartheid system. And this was published in the Stern magazine, which is a German magazine. And the same image was used as a cover page in an Indian magazine called Sports World. However, the Supreme Court decided to, use a more appropriate test of obscenity here, and they did away with the old Hickling test, and this time we adopted the American Roth test. Now, what the American Roth test is, pretty much presented over here. The test for obscenity derived from Roth that includes the following 5-part structure. 1, the perspective of evaluation was that of an ordinary reasonable person. In Hickling test, it was from somebody who was open to immoral influence and not exactly a reasonable person. The second is community standards of acceptability were to be used to measure obscenity. That is, it should be in conventional terms. Then works whose predominant theme was questionable were the only target of obscenity law. A work, in order to be evaluated for obscenity, had to be taken in its entirety. That is, it cannot just be taken just because, it was a nude photo shoot. We cannot ignore that the context was something of a very humanitarian purpose. That is a statement against the apartheid system, right? And an obscene work was one that aimed to excited individuals' prurient interest. It should specifically aim to the prurient interest and nothing else. It shouldn't have any valuable context to it. Now, when we're talking about this case, it was on humanitarian basis. A question might arise, what about artistic values? Because the artistic context need not always be on something that is, existing in our world. It could be a very fantasy-related realm, and could be anything of that sort, right? So, regarding that, in M.F. Hussein's case in 2008, the judgment and the Perumal Murugan judgment of 2016, both were in favor of artistic freedom. I'll explain the facts of the case. In the first case, basically, he was an artist who painted Bharat Mata and other Hindu goddesses in a rather obscene way, as per the definition of the plaintiffs. And in the latter case, he wrote a book which was called Mathoru Bagan, in which the main character was of a particular caste community, and the storyline didn't resonate with the actual caste community. And what the Supreme Court had to say is, art is often provocative and is not meant for everyone. However, it has its own artistic value, and this will be excluded when it comes to the question of obscene. All right, thank you. I pass the stage on to Anoushka.
Thank you, Shabnam. And you have explained beautifully about the basics of what cyber law is and the sections pertaining to that. Moving forward, we'll be delving into more deeper sections and the various punishments associated with those sections. Beginning with section 67B, which talks about how the Information Technology Act 2000 not only prohibits uploading or transmitting child pornography, but also browsing, which basically means viewing this, and all of it is punishable under section 67B. If anyone is found to be in possession of any material that amounts to child pornography, that person can be prosecuted under section 15 of the Protection of Children from Sexual Offences Act 2012 as well. Under section 67B, the punishments could range from imprisonment up to 5 years with a fine for up to 10 lakhs. And in the event of this happening for the second time, the imprisonment could be for up to 7 years and also a fine which may extend to up to 10 lakhs. Moving on, section 68, which talks about failure by certifying authority to comply with directions of a controller. Section 68 is a clear definition of power of control to give direction. Now, the controller, for that matter, may by order direct a certifying authority or any employee of such authority to take such measures or cease carrying on such activities as specified in the order, if those are necessary to ensure compliance with the provisions of this act. It basically means that if a superior officer or a superior authority can tell an authority below to do certain activities or to abstain from doing certain activities so that they are in compliance with section 68 of the IT Act. However, if such situations or such rules and regulations are not adhered to, it could lead to imprisonment for up to 2 years or a fine leading up to 1 lakh of rupees or even both. Shabnam, could you go to the next slide, please? Section 70, unauthorized access to protected systems. Unauthorized access is basically means you accessing something, you going into a laptop where you are not supposed to be, something that is of protected nature and you don't have authority to be there. For example, government projects where you are not allowed to access information, or any company or firms that have information that cannot be accessed by the general public, and you do that, then you are liable under section 70 of the Information Technology Act, and you will be imprisoned for up to 10 years, or even you may be liable to pay a fine, or in some cases both. Now, section 70B is a subsection of section 70, and it goes hand in hand with the above section. It is the failure to provide the information called for or complying with the direction of Indian Computer Emergency Response Team by the service provider, intermediaries, data centers, body corporate, or a person. This basically just means that if you have to give certain information about yourself, about things that you are aware of, to any government body or a service provider or any data center or a corporate body, with order that is, then if you cannot provide it, if you refuse to do so, or if on your part there is a failure to provide such information, the punishment for this under section 70B is imprisonment for up to 1 year with a fine which may extend to up to 1 lakh of rupees or even both. Shabnam, can you go to the next slide? Shabnam, this was a very, very, very small topic, and we have done our level best to cover sections that are extremely relevant to you and left out sections that are not that important for a legal awareness purpose. Now, I think Shabnam is in the best capacity to summarize everything and conclude. So, Shabnam, over to you.
Thank you, Anoushka. Well, it is time to conclude our session, of course, and the quote on the screen aptly sums up the current situation. The internet is becoming the town square for the global village of tomorrow. It is undeniable that all professional fields in the future will be on the internet, and everybody is going to be an internet user. So it is high time that we are legally aware of IT laws and cyber security in general. And of course, thank you for our presenters for putting up such an informative two-part session. And last but not the least, thank you everybody who have joined our webinar and you've been a very great audience to us. This is Shabnam Kodalil and signing off. Everybody have a wonderful day. Thank you.